So, a critical question that has been asked many times, and in many comments, I believe what would appear to be constables commenting, is saying that a right can be infringed on. I do not disagree. A right can be infringed on, a right can be abridged, and a right can be abrogated. But said right can only be infringed on if it is demonstrably justified in a free and democratic society. A right can only be infringed on being demonstrably justified. What it simply means is that it must pass a standard test. That test established by the courts, used in every single constitutional case, is called the Oakes test. In the Oakes test, there are many things that one have to go through. But one of the things I will highlight right here, which I would have spoken about in previous videos, but not in this context, is that the Oakes test requires that if the infringement or abrogation or abridgment of the right is arbitrary, then it is unconstitutional and it is not permitted. So yes, one's freedom of movement, one's freedom of liberty of the person, as is guaranteed by section 13 and 14 of the Charter of Fundamental Rights and Freedom, that's the Constitution of Jamaica, those rights can be infringed on. However, the infringement must be demonstrably justified, and the Oakes test, which we all can look up on the internet, look at the case laws. Many case laws are out there that discuss the Oakes test. Once it fails the Oakes test, then it is not constitutional. And one of the critical parts of the Oakes test is that the infringement must not be arbitrary. So again, it comes down to a public body, the Jamaica Constabulary Force, constables who are agents of the states. You must exercise your power in a way that is consistent with the Constitution. And for it to be consistent with the Constitution, for the infringement of the right, the freedom of movement and liberty to be constitutional or allowed to be demonstrably justified, it cannot be an arbitrary exercise of power. Such power must be justified when you're using it. Yes, you have the power to stop vehicles, and I will always say for section 91 of the Road Traffic Act, for the direction of traffic, or section 22 of the Constabulary Force Act, or somewhat many of the acts. But the exercise of said power is subject to the common law, and the common law states that for that exercise of power to stop a vehicle to be demonstrably justified, because constables, remember, once you stop a vehicle, you are engaging the freedom of movement. Yes, the vehicle is stopped, but you're also stopping the person. So which is one of the reasons people like me will ask you sometimes, am I free to go? Because you stop the vehicle, but you're also stopping me. It's two of us you're stopping. Two things, just one person and a thing you're stopping. The vehicle and me. Once you stop me, you're depriving me of my right to freedom of movement. Once you stop me, I must stop. That's what the law says. Once a constable stop you, you must stop. No, that is mandatory. Because, you don't know if it is a reasonable reason to stop you for. So you need to stop to find out. But constables, you must know, again, that section 33 of the Constabulary Force Act makes it very clear that you can be sued in tort for taking actions that are without reasonable probable cause or are malicious. And this is any action. So no matter what it is, if it's just to stop a vehicle, you must have reasonable cause. In other words, you must have demonstrable justified grounds. Evidence, demonstrable justified grounds to be able to exercise any power. So to tell someone that, I can stop you to check your documents, well, I understand detection by deception. And when the person who you stop just decide to comply, then they are waiving their rights. And at that point, that person can't protest at that point. But constables, you are leaving yourselves open up to litigation. when you take actions, as action that we want to classify as simple as to stop a vehicle, yeah, you must have reasonable justification, because without that, it's your actions are arbitrary. Alright, viewers and subscribers, like I said, if you look at section 33 of the Constabulary Force Act, that section expressly, I keep saying this over and over again, but I'm saying it for emphasis, expressly provides that a constable may be sued. You may choose not to sue, but may be sued in tort if they act maliciously or without reasonable or probable cause when they are taking any action. And any action means what it means, any action. So if you look, if they're exercising powers under section 91 of the Road Traffic Act, which gives the power to direct traffic, and yes, traffic means vehicle, person, blah, yes, it's defined in the section, in the definition section of the act. That said constable will need reasonable or probable cause. The Constabulary Force Act in section 33 is what impose that obligation. So not because that section is not in the Road Traffic Act or in the Parade Larceny Act or any of the other act. It don't need to be in every act. It is already in one piece of law. Then you have to understand that the wording there says any action, and any action again means any action. Any action simply means that if you decide to use your power under section 7 or section 20 of the Road Traffic Act, then you must have reasonable or probable cause to take said action, or you may be paying out millions or hundreds of thousands of dollars to an aggrieved party. Yes? So constables, this is for your own protection. We have to understand the Road Traffic Act might say, it says you under section 7 that on request by a constable, you must someone must produce the documents. And I've dealt with that, the must in that section already in previous videos. But like I said, that power is subject to section 33 of the Constabulary Forces Act, which makes it clear, and I say clear, crystal clear, that you must have reasonable or probable cause to take said action. Otherwise, you're liable for damages in tort. So let us humble ourselves. And again, Emans versus the Attorney General. That case in 2013, Justice Batts made it very clear in no uncertain terms that the request in paragraph 58, that the request for documents and driver's license must follow some existing cause, such as reasonable suspicion of an offense, yeah, or reasonable or probable cause. Those are clear interpretation in both statute and common law. So let us not fool ourselves. And reasonable cause means what it means, like I said in previous video. Reasonable. It must be, it's an objective standard. It must be what a reasonable person would do. That is what takes the arbitrariness out of the decision to exercise the power. The fact that there is a requirement for reasonable cause or reasonable suspicion. Without the reasonable element, then it would be arbitrary. Yes? But the reasonableness put a standard of a reasonable person. And that's a standard that any court can assess and say, all right, this action based on the facts and the law and all the circumstances was reasonable. It was justified in law. So the right, yes, can be infringed, but the right can only be infringed if the statute makes it clear that the constable must have reasonable probable cause to take any action. Otherwise, that is one condition under which the constable may be sued, and then if found guilty of that action without reasonable probable cause, can be paying millions, if not hundreds of thousands of dollars in damages to an aggrieved party. Until next time, the audit the law fans. Bless.